there's plenty of debate about what those powers are, how extensively they've been regulated. But the underlying theory is that the federal government has fewer powers than government in general could exercise. And so the federal Constitution is much more of a framework document that sets up structure and declares some basic values and rights. State governments have a lot more power. I don't mean to say that states can do anything whatsoever. There are clearly some basic federal constitutional limitations, and there are some principled restrictions on what we think government at any level should do. But because state governments have more general powers than the national government, almost by definition, a state constitution will be more detailed and subject to more frequent amendment simply because it has to deal with more details. I'll come back to talking about how that plays out and some particular aspects of the Ohio Constitution that have led to a lot of the proposed amendments over the last 20 years or so. But I want to come back to something that Steve said at the outset. There are several ways to amend the state constitution. Steve walked through them, but the General Assembly is involved in some of them, for example, by joint resolution, as well as through the General Assembly's power to call its own constitutional convention if it thinks that's appropriate. And then we have arrangements either for the people to vote in for a convention, the every 20 years provision that Steve mentioned, and the provision for initiated constitutional amendments. But whatever the process for amending the Constitution we may be talking about, in the end, as Steve indicated, the people will ultimately get to vote. All of these mechanisms are inherently political. And whenever you have a political process, we always face the possibility that special interests, however defined, will get disproportionate influence. Now, I want to just take a couple of minutes to talk about some of the proposals that we've considered in Ohio over the last 15 or 20 years, because I think they fall into maybe 2 or 3 different categories. On the one hand, we have some pretty significant policy questions. For example, in 1992, the people amended the Constitution to impose term limits on federal and state officials. It turns out that the federal term limits are unconstitutional under a Supreme Court ruling, but the state term limits are still with us. Whether they're a good idea or not, we can debate about, but at least if we're going to have the Constitution setting up the basic structure of the government, you'd think term limits would be an appropriate subject for us to think about putting in the Constitution, whether we like the idea or not. In 1994, the voters amended the Constitution to create a kind of a victim's Bill of Rights. In 1995, in response to a state Supreme Court interpretation of the Constitution, we limited the governor's power to commute sentences. In 2004, we amended the Constitution to define a marriage as being between one man and one woman. In 2008, we amended the Constitution to provide for expanded property rights in groundwater and lakeshore properties. In 2005, we considered and rejected a whole raft of changes to election law, campaign finance, redistricting, things of those sorts. Again, we might disagree about what the right answer is, but the notion that these things are cluttering up the Constitution or are inappropriate, it strikes me as a hard argument to justify. We can argue about what the rule ought to be, but those seem to me to be the kinds of rules that we ought to think about. Now, we've also voted on a series of amendments that have been extraordinarily complicated over the years. Indeed, they're so complicated they actually look a whole lot like legislation. For example, we have amended the Constitution to prohibit sales taxes on soft drinks. We have voted on and rejected a very detailed proposal for drug courts. We have adopted a very elaborate formula for fixing the minimum wage and adjusting it periodically by way of inflation. And most recently, we amended the Constitution to provide for the creation of 4 casinos at specified locations in the state. Indeed, after we did that, the people in Columbus decided that the location that was enshrined in the Constitution wasn't to their liking, so this year we had to vote again to move it. And we've voted on a number of other things. We've voted on the Third Frontier program several times, and a variety of other measures. And some of these proposals have wound up being debated as constitutional amendments because the proponents understand the political advantage of enshrining their policies in the Constitution. It's a lot harder to change the Constitution than it is to amend ordinary legislation. But there's another reason why we have voted on a lot of these things. The Ohio Constitution contains provisions that strictly limit the kinds of public debt that we can incur. And as a result, every time we want to sell a bond, do a bond issue, for example, or make a major public investment, we have to go out and amend the Constitution. And there's a section with, what is it, something like 25 or so provisions that incrementally authorize these things. We don't have to do that at the federal level, but we do have to do it at the state level because of the way the Constitution is structured. Similarly, we've been voting on gambling and casino proposals a lot over the last 20 years because the Ohio Constitution has provisions that strictly limit the kinds of gambling that are permissible. And given the number of times that gambling and casino proposals have gone down, I suppose we shouldn't find it a great shock that the people who wanted the new round of casinos decided that the only way they were going to be able to get it was, number one, to amend the Constitution, and number two, to do so in a way that would respond to claims that the proponents were trying to get us to buy the proverbial pig in a poke. Now, I'm not offering this as necessarily a good thing. I just mean to suggest that we ought to put these things in perspective. One last general point. When you look over the last 15 or 20 years at the votes on proposed constitutional amendments, the overwhelming majority of successful constitutional amendments have gotten upwards of 60% of the vote, sometimes a lot more. The main exceptions have been on the Third Frontier, which got around 54, 55%, and the casino amendment last year, which got only 53%. So even though the Constitution authorizes amendments by a simple majority of the popular vote, it doesn't appear that a simple majority has been enough, just as a historical matter. Whether we should set the bar higher, we can talk about, but it's not like the Ohio Constitution is full of amendments that were adopted by 51 to 49. Finally, some aspects of the process of amending the Constitution, while they are inherently political and messy, are things that we really can't do much about. I mean, for example, most serious proposals to amend the Constitution involve paid petition circulators. And the theory is, well, maybe if we didn't have paid petition circulators, we wouldn't have to put up with this. Unfortunately, The United States Supreme Court has said that the First Amendment protects the right of proponents of various measures to go out and pay petition circulators.